lawyer leading the charge for the players on that lawsuit is Ted Charney of Charney Lawyers, and Ted is back on the show. Last time he was on was back in October of 2014. Ted, welcome back to Offside.
Thanks for having me back, Eric. I'm still alive and kicking, despite the years that have gone by.
It's funny, for our listeners, they say 6 years for a lawsuit. Wow, that's a long time. But I would, in the case of a class action lawsuit like this, 6 years, Ted, doesn't strike me as a long time. What are your views on that?
It seems like a long time to me. We've been through a lot of wars on this case and all sorts of battles and appeals, and we've been fighting it on 3 different fronts and the court of public opinion. It's been a long, hard battle, and I, for one, am glad to see that it's now finally settling. I was hoping to get some money to these players before they're all in their mid-30s or early 40s and have forgotten all about playing hockey.
All right, so Ted, before we get into this settlement valued at about $30 million, I just want to sort of set the table here. Let our listeners know, who is Sam Berg and why is he important?
Sam Berg is the son of former NHL hockey player Bill Berg, and he lives in St. Catharines, Ontario with his folks. A wonderful young man. I just so happy that I originally met him. He was the original driving force behind this case being advanced, along with another fine young hockey player from Vancouver by the name of Luke Walter. And together, the two of them met with me, and we were able to commence 3 class actions because the two of them came forward. Sam headed up the Ontario Hockey League case because he played for the Ice Dogs. Luke played for one of the U.S. teams in the WHL, Tri-City Americans, and he also played for a team in the Quebec Major Junior Hockey League. So Luke was able to cover off 2 of the class actions that we started. You need at least one representative plaintiff to start a class action. And so after those 2 came forward, it was years, many, many years before we found anyone else who was willing to be a representative plaintiff. And the 2 of them put up with all sorts of ridicule. They were criticized by their own family members. They were criticized by the media. They were vilified by the leagues. Many major junior hockey players, when it had nothing to do with this case, at the time they thought it was the wrong thing to do. And nevertheless, they persevered despite all of the media attention, despite all of the personal attention from their friends and family members, and they pressed on for the entire 6 years with this litigation right to the end.
Speaking with Ted Charney, Charney Lawyers, lead lawyer on the class action lawsuit brought against the CHL. I had you on the show back on October 21st of 2014 because I believed that this lawsuit was in lockstep with what was going on in the U.S., and this was a good idea. So this lawsuit is settled for $30 million. Ted, what are sort of the key parts of this settlement?
It's intended to provide some degree of fair compensation to the players who are played in the league during the years when the compensation was still available before the leagues basically exempted themselves from the employment standards legislation in virtually every province in Canada where there is a team located. And that is the most important part of the settlement, is to provide some compensation to the players who, during their tenure in the leagues, were making $50 or $35 or something in that range every week. Now that their careers are over, not all of them have done financially well. A number of them have sustained some pretty severe injuries over the years, and it impacts their ability to find gainful employment. Not everyone took advantage of the education, the scholarship, and so we're hoping that this settlement will provide some compensation for the players that need it most.
I think it's important to note, Ted, that this educational option the players have, if they don't exercise that within 18 months of no longer playing the CHL, then they lose that right, correct?
Yes.
And so, look, so let's go back to what was the sort of the focal point of this lawsuit, and that is, are these hockey players employees, in which case they should get paid, or are they student athletes or interns? So what, in your view, made the players employees and entitled to payment for their services?
There was a host of factors that led us to that conclusion. Do you know, historically, at one point, the standard player agreement that every player has to sign in all three leagues, and then it has to be sent to the commissioner who has to co-sign it, that way back in the day, and I learned this in a very funny way, way back in the day, the standard player agreements used to say that the players are employees and used to describe them as employees who were playing for a wage. And we got our hands on one of those old agreements, and the way we got our hands on it is it happened to be framed and on the wall at this bar called Gretzky's in Toronto, and it was Wayne Gretzky's standard player agreement.
I love it. I love
back in the day. And then since then, there have been a number of iterations, but the leagues have never really gotten it right. Sam Berg's player agreement characterizes him as an independent contractor. So for us lawyers, we know an independent contractor is someone who's self-employed working for themselves. They're not actually an employee. And so here you have a 16-year-old who's signing a standard player agreement where he agrees he's an independent contractor. I mean, there were so many different hallmarks of an employment relationship that we thought were important to advancing the case. The standard player agreements, the way they were worded, there was a couple of court decisions that had found the players to be employees.
Right, there was a tax decision, correct?
There were tax decisions, and then through the players and through agents and other sources, we were able to collect countless numbers of T4 slips and records of employment and other indicia. And then in the litigation, there was an undertaking that required the commissioner to produce some documents, and we got a directive that was sent to all the teams by the commissioner telling all of the teams to stop classifying the players as employees and stop issuing them T4s and so on. So, I mean, there's the standard hallmarks of when someone is considered to be an employee as opposed to an independent contractor. But what complicated this case is that two things. The leagues were not litigating this case based on the usual legal test about whether you're an employee or not. They were saying that the players are student athletes that are in a development league, and that this issue of student athletes had never really been determined under any traditional court-type test because no one's ever litigated it before, and that the usual test for whether you're an employee or not doesn't apply here because this is an entirely different animal, and they refer to other amateur athletes in different types of profession, different types of sports and Olympics, and they built up this whole argument about how we don't use employment tests for this situation. And so that's the battle we had, but then they changed the entire situation by getting lobbied out of the legislation. They actually convinced the governments in every province to exempt them from employment standards legislation on the theory, I guess, that they were concerned they were going to lose the court case. So why litigate the case in court when you can exempt yourself from the case? And they managed to do that.
So then, Ted, if the allegation or the position is being taken that, hey, the CHL teams don't have enough money to pay these players, what's your response?
Well, we had one of our major legal disputes with the leagues was production of all of their financial statements and their contracts with that were generating TV revenues with Sportsnet, their NHL contract, and we won in court, and they had to produce everything, and we were able to demonstrate that the revenues are very significant, in the range of $100 million a year in revenues for the teams, and the contracts they have with Sportsnet and with the NHL are very significant. But more importantly, the way they typically argue this, they say that some of the more popular teams, more successful teams, do have significant revenues, but most of the teams don't. And when we looked at the financial statements, pretty much across the board, no matter how high the revenues were for a team, and some of them were quite high and others were not, by the time they got finished with whatever expenses they had, they all seemed to break even or lose a little money. So, take a team that's making $30 million a year and another team that's making $4 million a year. They both end up more or less with the same net income. And it seems to be right across the board. They all seem to have an ability to just break even. So, the types of expenses that are on these financial statements are not necessarily conventional expenses. In some cases, the meals and entertainment expenses were more than 3 times what it would cost to pay minimum wage. That kind of thing.
Speaking with Ted Charney, lead lawyer on the CHL class action lawsuit against the CHL, the argument that the players were student athletes. Okay, so I teach sports law at the University of Ottawa. Okay, and we talk a lot about the NCAA and their student athlete paradigm. At least in that instance, Ted, the players are actually in school. In this case here, the players get a credit they have to use within 18 months, but they're actually not in school. And so it strikes me as a rather strained argument to take the position that they're student athletes when they're not even in school.
Well, that's the approach that we took, and I agree with you. That was the approach that we took. Unfortunately, there'll never be a court decision on this now.
Well, let me ask you this, Ted. How upset or annoyed were you when each CHL province enacted their legislative amendments exempting players from being considered employees? This was after you filed your lawsuit. You just talked about it, but emotionally, were your clients upset? Were you upset? Were you annoyed?
Yes, it was very discouraging that for us that when we're already in court, litigating the case in a courtroom, that legislatures in all these provinces wouldn't allow the court to do its job and make a decision on this case on the merits. But it became increasingly obvious that the lobbying efforts of the leagues was going to be determinative in terms of the legislation exemptions, in part because Canadian hockey is so important in our culture and fabric, and politically as well, and in part because a number of these clubs do make a significant contribution to their communities, both in terms of providing an entertainment product and employment, and generate business and sales for their communities. And they're frankly the only game in town. That's their business model, is they establish franchises in locations where there's really no other competition. So if anyone wants to go to a sports game on a Saturday night, in a lot of the smaller cities and communities across Canada, this is the only sport that's available. And so they're very important in their communities, and they have a lot of political weight because of that.
Speaking with Ted Charney, lead lawyer on the class action lawsuit against the CHL. So, Ted, let me ask you, what do you say to people who say, Sam Berg, quit your whining. They gave you spending money, free room and board, exposure, a chance at a scholarship, and you just didn't make it into the show, and you're just bitter, and you're just upset. What do you say to them?
Well, what I would say to them is that unless you actually experienced playing in the league and understand the amount of effort and commitment and experience that is involved in being a player in major junior hockey, you wouldn't understand that in reality, people like Sam Berg feel like they were really working and that they were generating significant revenues for their teams while they were not recovering anything in the way of wages. And that there is a lot more to this than just players that didn't make it into the NHL. I mean, the players who are the plaintiffs in these proceedings felt that they needed to try and change major junior hockey, not only for themselves, because they're not even in the league by the time they filed the lawsuit, but for all the players that are in the league. And they felt that there needed to be some major changes based on their experience playing in the league. Sam Berg did not go through everything that he went through in this case in order to recover the kind of money that we're talking about here. He went through this because he thought it was a worthy cause and that someone had to pick it up and run with the cause and nobody else would.
So, Ted, you've settled the case for $30 million, but you've got these legislative amendments in each of the CHL provinces that preclude players being deemed employees. So moving forward, practically speaking, it's what our listeners probably want to know. Practically speaking, what does this all mean for future CHL players? Does it mean anything at all, or is this intended to make whole players who had previously played?
It's intended to make whole players who previously played. From our perspective, we'd like to believe that the class action resulted in there being a significantly increased focus on the way these leagues interact with their players and the role that the players have in the leagues. The class action received a tremendous amount of media attention, a tremendous amount of scrutiny from all sorts of different sources. And during the period when the class action was continuing, the leagues did implement new benefit programs for their players and seemed to have taken a heightened interest in the importance of developing their players now and going forward. I'd like to think that that has something to do with the fact that the class action focused so much attention on the activities of the league. Until this class action came forward, the league and their teams were effectively closed communities where there was very little known about how they operated outside of the people who were on the teams and their players. And to a large extent, I think these class actions opened that community up in a way which they can never really go back to being the closed community that they once were. And I think that's probably good for the players. I also think it's probably good for the teams and the leagues, and that some good came out of this from the way that they've now perceived their relationship with their players.
I think that's well said, Ted. I mean, I know everyone hates lawyers, including my parents, but the value of well-placed litigation is that it can advance in a constructive way. It can advance issues such that they can be resolved or at least addressed in a meaningful way, and by extension, elevate all of us. And I think this is what this lawsuit did. So I commend you on the lawsuit. I commend you and congratulate you on the settlement. I know it is tough. That was a tough road for you. And I want to thank you so much for joining me here, Ted, on Offside.
Well, thanks, Eric. I'd just like to say something about the leagues. I'm really appreciative for their efforts to try and resolve this case. I think they've done the right thing and that they've tried to bring this to a conclusion, which is in everybody's best interest. And so they should be congratulated on doing that as well.
Well said, Ted. Again, thanks for taking the time to join me here on Offside.
Thank you very much, Eric. Thank you very much, Eric. Thank you very much, Eric.